Hello, everyone. I am Fabrice Langrenier. I will be chairing this panel entitled Vulnerability 2. After the first one we got yesterday, this one is about children in refugee status determination. Today we have three speakers, three lawyers who all share concern for children in legal procedures and in asylum procedures, and they all use an interdisciplinary set of tools and methods. So that will be fascinating to hear them exchange their views and share them with you. So we'll start with Stephanie Rapp, if that's okay. I'll introduce her and give her the floor. Stephanie is assistant professor at Leiden University in the Netherlands at the Department of Child Law. She works on the effective participation of children in legal procedures. She's doing a postdoc research on the participation of refugee and migrant children that's funded by the Dutch Research Council. And she combines law with various insights from the social sciences. She's also lecturing in advanced studies in international children's rights. She's a member of editorial boards for the Flemish Journal on Youth and Children's Rights and the Chronicle of International Association of Youth and Family Judges and Magistrates. Stephanie, the floor is yours. If you want to share your screen, you can do it now.
Thank you for the introduction. I will start sharing my screen first.
And please, if you can aim at 20 minutes roughly, that would be fantastic.
I will. Okay, thank you. So I will present today indeed about a part of the postdoc research that I've conducted over the last three and a half years. This is the part in which I have conducted observations of asylum interviews with children below the age of 12. The other parts of my research were also a legal analysis, but also interviews with professionals working in the asylum and migration system in the Netherlands, and also interviews that I've conducted with young people, which I've recently concluded that part, but I will focus on one part today. So my research stems from the UN Convention on the Rights of the Child. In this convention, I think with the adoption of this convention, I believe that children have been given specific rights and protections, and we're also increasingly seen as specific rights holders, and not only as children who need protection against violence, for example. And they also have been increasingly seen as active agents in exercising their rights. The International Children's Rights Convention moved away from a very paternalistic view on children to seeing them more as a separate category of human beings who needed special protections maybe, but also have our own voice in there. There's one specific article on refugee and migrant children, which highlights the importance that the children need appropriate protection and humanitarian assistance. But also in the second section of this article, it states that these children should be given the same protections as other children who might be deprived of their family or social environment. Some have also indicated that this article is important in highlighting also a child rights interpretation in the Refugee Convention, because in the Refugee Convention there are no specific provisions on children, and the CRC provides for that in Article 22. Protection and participation are parts that are seen as highlights in the UN Convention on the Rights of the Child, and this participation part is where I focus on in my research. because there's one specific right, the right to be heard in Article 12 for children, which indicates that they should be heard in all matters that affect them in their lives, and specifically also in judicial and administrative proceedings. So they should have the right to be heard by authorities in cases where decisions are taken in their lives. And this is also a very child-specific provision, because you cannot see this in other human rights conventions for the general population. But it has certain implications, because it means that proceedings need to be adapted to the age and maturity of children, that there should be accessible ways of hearing children, and also specific places where children are heard by professionals who are have some form of specialization and training in hearing children. Another important aspect of this is also that children should be informed about this right, but also how to exercise this right, and what type of procedure they are involved in, what is expected from them when they are heard in the proceedings. And the UN Committee on the Rights of the Child has, specifically in General Comment number 12, given quite some recommendations to member states on how to implement the right to be heard, and also that the right to information is an important aspect of that. They also indicate that this is also of very much importance for children who are involved in asylum and migration proceedings. And that, for example, it is important to also make specific best interest assessments of children to see what role do they have in seeking asylum as a family, for example, or alone, and how can they be best protected. In my research, I've also looked at earlier research on the involvement of children in legal proceedings and also in asylum proceedings. And there has been quite some research on children who are, for example, involved in court proceedings where their parents separate, or in care proceedings where they have to be heard by professionals. The large body of research indicates that children, when they are asked about it afterwards, find it very important to be heard about their own situation, so that judges can make a decision on their case while they have actually seen and heard the child. Research also indicates that it has, being able to participate and being able to give your views on important decisions in your life has a positive influence on, for example, feelings of self-confidence and self-esteem. On the other hand, when children are not involved at all, they feel out of control, they feel frustrated about it, they feel powerless about the situation and not being able to give their opinion on the issues. It's also important for their acceptance of the final outcome, the decision, and a better understanding of the decision. Because when they are heard and when there is also a personal conversation going on with a judge or another decision maker, it's easier for the child to understand how and why certain decisions are taken. On the other hand, a lot of research also shows that children want to be informed better about what is expected from them, about what will be asked, about the type of conversation that will be held, and they mainly indicate that they need more information. In light of this part of my research, I also looked at the interview practice of young children, because this part of my research is about children who are below the age of 12, because they are interviewed by the immigration authorities in a specific setting, which I will tell a little bit more about later. But you see there that in forensic settings, where children are interviewed, for example, when they are a victim of violence or sexual abuse, for example, that there are very specific requirements needed in order to obtain the views and also evidence from children, because it is a very unfamiliar setting for children to be interviewed. Normally they are asked questions in class, for example, and teachers are the ones who already know the answers. But in these kind of settings, children are heard as an expert, and they do not need to give answers that are in line with the expectations of the interviewer, but they have to give their own opinion or their own views on a case or on a specific event that they have experienced. So this requires a setting in which the ground rules are very well explained to the child, that the child understands why it is asked these questions, and that the person that is in front of him or her does not know the answers already. So some type of specialization and training is needed for that. And for example, the Netherlands special police officers are trained to have these kind of interviews with child victims. You can understand that in migration, the same kind of topics can also be discussed. Very emotional topics, very difficult topics of children who have fled their home country, are alone, not with their parents anymore. Yeah, the previous research indicates that there are a lot of challenges with regard to interviewing children in these kind of, in asylum proceedings. And that it is important that children are informed about what they will be asked about, for example. So about the research that I've conducted, I was able to observe videotaped interviews with children below the age of 12. These hearings or interviews are videotaped because of the young age of these children, and that's I was not able to actually sit in those interviews live, but I was very happy to be able to have access to the DVDs that were made out of that. I have seen 13 and analyzed 13 interviews. There were 4 girls and 9 boys, and their average age was 9.5. The youngest was 7 and the oldest was 11. And their countries of origin were varied. And some of those children also lived in other countries because they had fled from their home country at a young age already, and then lived also in Turkey, for example, before moving to the Netherlands. So these interviews were held in a child-friendly interview room, as they call it. There's one in the Netherlands. And this room is equipped with audiovisual recording devices. And the child is having the interview with the immigration officer and an interpreter. And there's no support person with him or her, because that person, like a guardian or a family member or a foster parent, needs to sit in the other room where the interview is live streamed. They have chosen for this way of working in order for the child to have, to be able to, speak as openly as possible and to have less people in the room to distract the child. The interviews that I've seen lasted on average 49 minutes, and some had 1 or 2 breaks. Specifically in this room, there's also a space for movement. So there's a podium inside where the child can go sit on or walk on. There are toys in there. Children can have drawing paper and pencils, so they can make a drawing, for example, and color. And there are also specific puzzles and folders with photos inside that can be used in order to enhance the communication between the child and the immigration official. So I analyzed these interviews based on 3 subjects. So I looked at how the child is prepared and what kind of explanations are given. I looked at the content and types of questions that are asked. And I looked at what kind of conversation techniques are used by immigration officers. So to move to the first point, the preparations start when the child enters the room, and first the technical issues are explained to the child, so that there are cameras, that the audio is recorded, and that there's another room where the guardian is sitting, and where where a television screen is, where they can see the child and the immigration officer. So most interviews start with that technical explanation. of how the room works. And then some explanations are given on the goal of the interview, the ground rules, and what is expected from the child. But this is not done in all interviews. So you can say that this very well explaining of what the whole situation is and why the child is there is in sort of half of the cases is lacking. And also the immigration officials do not devote that much attention to checking whether the child really understands what is said or understands the reasons for asking certain questions, for example. Most say to the child that he or she can say, I don't know, to a question. So that is something that they have prepared very well, that the child does not have to answer to all the questions because they may not know the answers. So that is also about, that's the quote that I put on the slide about saying, I don't know. Then about the content of the interviews, as you already saw, 49 minutes speaking with a child between 7 and 11 is quite a long time. So you can imagine that, a lot of questions are asked, and immigration officers try to, get information from the child, but in a lot of cases it's going quite, it's not so easy, and it is quite hard for the officials to really get the conversation going and to have the child really disclose much information by themselves. And this also has to do with the fact that they ask many closed-ended questions. So they ask a lot of questions where you can only answer to yes or no, and then the child will do so and not really elaborate on that. So they give very short answers, and also they have highly detailed questions to the child. They are factual by nature, and they ask for a lot of detail about living places where children were living, how houses look like, about family members and where family members lived before or now live, and also the names and the ages of certain people, which is all, they have to collect a lot of, or remember a lot of facts to disclose at the interview. And sometimes it's also quite difficult information that they ask. They ask, for example, sometimes about ethnicity of the child, whether it is a Palestinian child or a Yazidi child, or whether they're Syrian. So they have to also know about these different ethnicities that live in a nation state, for example. Or they ask about travel documents and whether the child had received stamps in their passport or not, and whether they actually know what a passport is. What is quite telling, and that's also the quote that I put on the slide, is that a lot of children ask at the end, what will be done now next? What is the whole reason to be there? And the main question that most of them have is, can I stay here? And when can my parents come? Because that is in a lot of times, of course, the goal, that they ask for family reunification later, because they are staying with all their family members or are completely alone. And that is, probably not very clear from the beginning of the interview for the child, so that they come back to that at the end again. Then about the different conversation techniques that are used. You see that immigration officers have had some training, that they, for example, use small talk to make the child feel at ease, use the drawing and coloring material so that the child can do something during the interview. And they also compliment the child, for example, at the end, that they say, okay, you did very well, and you have, you've done a great job in telling all this information. But the very specific tools that can be used in the interview, like the drawing board that is there, and the podium, they have dots on that, so the child can walk over the dots and tell their story. That is not much used. There are only a few interviews in which I really saw that they were moving around in the space, and were using the space actually to have the conversation. And the quote is about using those dots. And there it was really interesting to see that the immigration officer with the child went to the podium and said, okay, we'll stand on the first dot, and where did you live? And then the boy says in Turkey, and then where did you go then? And then next, and then next, to trigger the memory of the child. And at the end, it was really funny to see that the boy also went there to stand on his head even, and doing some other type of funny exercises, because the child was doing something, it was not really thinking maybe too much about being interviewed, but more doing something fun. But overall, I can conclude that it differs substantially also with using these techniques between the immigration officers, whether they actually use that and also make use of the space. The same can be said for the preparations, that some of them did quite well, but other ones were very brief on really guiding the child through the interview. To conclude, so my research stems from the idea that the right to be heard should be upheld for children in asylum proceedings as well. And from the CRC and the UN Committee on the Rights of the Child, there's this clear view of that every child should have the opportunity to be heard, to give their true voice in a child-friendly environment, and that they also should be able to say, okay, I don't want to give my views. But in practice, and being involved in asylum proceedings, the reality is much different, of course. The aim of the interview is to collect information and evidence to assess the asylum application of the child, and not so much to hear the voice and giving the child space to give their views on what they would like to be happening. Also, I think the difficulty is that these procedures are highly complex, are difficult to understand for children and young people, that there is, of course, a power imbalance. The child is asking something from the state, is filing this application. And therefore it is also what I learned from the interviews with young people, it is not so self-evident that they will really disclose all their information and all their views. But I think to improve, there are possibilities to improve at least how to communicate with this group of very young unaccompanied children. I think immigration officers can be far better trained in how to ask questions to young children, to give them more space to really openly recall what they have experienced, and also to really also maybe have more of an interest or a best interest assessment or individual assessment to see whether it is actually needed to interview these very young children, because I doubt a little bit what benefit it will have in the end to the asylum procedure and the child itself. So these are the results that I wanted to share with you, and I look forward to any questions. Thank you.
Thank you so much, Stephanie. And thank you for the timekeeping as well. That was perfect. I already have a number of questions for you. I'm sure other people in this room do as well. We're gonna keep them for the tail end of our session for the Q&A, and we'll move immediately to Diego's presentation, if that's all right with him. So Diego Castillo Gonçalves is a doctoral researcher at Trinity College Dublin in the School of Law. And before his PhD, Diego worked as a legal advisor with Asylum Access Malaysia, and also as the Children and Young Persons Officer with the Irish Refugee Council. Right now, he's also involved as a project leader with Safe Haven Ireland, which is an NGO in Ireland that focuses on migrant and refugee youth integration. And so Diego's research is at the juncture of asylum, migration ethics, and children's rights. Diego, do you have a PowerPoint to share? If so, please do. And if you could also aim at 20 minutes, that would be fantastic. The floor is yours.
No worries. Thanks very much, Fabrice. Let me just Share the screen now. So thanks very much for having me over today. Thanks to the organizers of the ASYFAIR conference. I'm delighted to be here, and I'm really happy to be in a panel focused on children in status determination as well. I think it's great. I'll try to go through it as quickly as I can in terms of timekeeping, but do shut me up if I pass through the 20-minute mark. So in terms of the more or less the structure of my presentation, what I would like to do today. So my paper explores how credibility assessment of separated children is being operationalized in Ireland. I tried to do that through mapping credibility outcomes for children in light of the data that's available at an appeal level at the International Protection Appeals Tribunal Decision Archive. So it is more of an archival analysis of written decisions. I acknowledge that there are limitations with this methodology. So what I try to do I start by conceptualizing what I mean by operationalization in the Irish asylum context. I then consider 57 decisions regarding status determination of separated children from 2016 to 2019, including those where credibility wasn't decided at first instance. I then proceed to analyze through these decisions how certain procedural issues arise, but as well as I try to identify sub-themes that have emerged, such as the overuse of inconsistencies to reject children, as well as the use of stereotypes to question children's abilities to make their own decisions when it comes to their migration trajectories, as well as the over-reliance on age to establish overall credibility. And then finally, I tried to attempt to outline how children's rights were currently placed within this assessment of credibility at the appeal level. I note that the Convention on the Rights of the Child is only occasionally paid attention to, but as well, I tried to argue in my conclusion, what is the image of the child that emerges out of these decisions? So just to give you some context background in Ireland, so Ireland has had a really low number of separated children spontaneously arriving in the state, meaning that it has also had less scrutiny when it comes to the quality of decision-making in relation to this population. It has also had less literature available on children's experiences of navigating the asylum procedure. As you can see here, Ireland only received 240 applications from separated children between 2014 and 2020. So that's why all of the cases that I looked at, these are pretty much all of the cases that are on the archive itself during that period. It recorded children from Albania, Afghanistan, and Iraq as the main protection claimants between 2017 and 2019. And when it comes to decision-making, the focus has been placed mostly on pointing out issues associated with delays and resourcing of the system itself. Which means by that is that the focus has not been on the quality of decision-making or on the outcomes for the people who apply for asylum. The overall focus as a result of that has actually been on reception conditions, namely the direct provision system in Ireland. So, which means that the decision-making process itself has kind of fell to the sideline. And you can see this in these reports that are cited just previously. There's very much an emphasis on lengthy processing times and lack of early legal advice, but there isn't really much in terms of transparency regarding interviews or in terms of the way these interviews are conducted. So in terms of the legal framework in Ireland, and I'll focus just on the domestic level, if that's okay, that separated children are dealt with through the International Protection Act 2015, which is the act that enshrined the state's obligations in the international and European refugee law, including the Procedures Directive and the Qualifications Directive. So the Act actually introduced for the first time a single procedure for examination of protection applications, and that includes refugee status and subsidiary protection. Before that, it was a truncated procedure, meaning that people had to apply for refugee status and then for subsidiary protection and so on. In Ireland, separated children arriving in the state, they are referred to the Child and Family Agency, TUSA. TUSA then determines as to whether to make an application for the child or not. The child in Ireland doesn't have the capacity to apply on their own, which has been pointed out by the literature as being fairly problematic. At first instance, credibility of children is assessed by the International Protection Office within the Department of Justice, and that the appeal stage responsibility is with the International Protection Appeals Tribunal, IPAT. These decisions may be subject of judicial review, and Ireland does not provide for a definition of credibility in legislative terms. So even though it doesn't, Ireland tends to use quite often in the appeal decisions the UNHCR handbook on procedures and criteria for determining refugee status. It tends to be the more influential instrument used during those decisions. So moving on then in terms of what I mean by operationalization, in the way that I see it and the way that the literature defines it, it relates to the process of translating law and policy from law on paper to that which is referred as living law, namely one law which one can actually infer indicators from, questions, and benchmarks of assessment. So my primary aim with conceptualizing these indicators and creating them more or less is that to find out whether law, particularly in its procedural dimension, has been fulfilled and how it has not been fulfilled. So within the status determination, for instance, the point is to describe, therefore, how children are singled out within this procedure, either as to whether they get protection or they get rejected on the basis of their credibility. And I tried to look, for instance, what are the outcomes, but also whether obligations have been met and what's the conduct of adjudicators in that sense. So my approach, I think, reflects that's been argued by the literature, namely that studying operationalization requires some type of interpretive action as well, including when it comes to developing these indicators, which is what I'll touch upon now. So key to considering operationalization itself, it comes to developing these indicators. So an indicator is supposed to be a tool to measure the operational reality of particular legal rules for individuals or groups, such as unaccompanied children in this case. I see these indicators, though, through a mixed methods approach where quantitative and qualitative measurements of operational reality intersect. So I consider both numeric information, such as children's social demographics, as well as the substance of these written decisions, such as how credibility is formulated, as well as how adjudicators approach children's agency or how they approach the way children make decisions about their own lives. So some of the scholarship makes a difference between quantitative and qualitative indicators, which the first provides for numeric information, the second for some type of judgment. But I think that suggests a more binary approach to operationalization and kind of neglects the fact that numeric information also originates from some type of judgment in itself. So in terms of the indicators that I worked with, and you can see here the way that I have looked at them and the way that I have conceptualized them in this particular context is that for me, structure indicators, when it comes to credibility assessment, they demand one to reflect upon whether the legal instruments are there, but also whether there are dedicated institutions to perform these and whether the actors that are within these are trained enough and qualified to perform these activities. The process indicators require measuring then the actual functioning of these procedures in light of the structure indicators, as well as to the degree as to whether they exist in practice. So for instance, whether there are procedural guarantees in place, processing time, the influence of external actors such as social workers and guardians. And finally, outcome indicators, the way that I have viewed them, relate to decision outcomes as well as the influence of the children's rights regime. And I put the influence of the children's rights regime there because I wanted to see that, in my view, outcome indicators are both the product of how credibility is being assessed, but also how the structural environment, also of the structural environment from where these decisions come through. So I just wanted to see how children's rights itself whether they have any influence on this structural environment, if that makes sense. So in terms of the decisions that I looked at all the decisions available in the archive during that period. And I did that to flesh out the role played by credibility through different stages of determining a child's claim. So not all the decisions are status determination or credibility related, but all of them have a credibility element to them, more or less. And a lot of themes have emerged out of this manual coding, if you want to say it that way, that I've done in terms of looking at the cases. So to do that, I paid particular attention to certain things such as credibility assessment outcomes, social demographics, profile of adjudicators, and the use of the law itself. Some of the themes that have emerged have included use of inconsistencies, influence of external actors, and as well, when it comes to this, as you can see here, 87.8% of the cases that were rejected and came at an appeal level were done so on the basis of credibility. And 50% of these cases were overturned in relation to children. And it's a much higher percentage than when it comes to the general profile of asylum seekers, where only 38% or 36% of the cases would have been overturned, which tells you there are some problems with the procedure just on that basis. So when it comes to the social demographics of the children that I looked at, of the written decisions that I looked at, the majority of the children were coming from Albania or Afghanistan and Nigeria. But the interesting thing is the age that children apply for asylum in Ireland. So the earliest age will be 12, And this would be a really minor proportion of the children. Now, as you can see there, 56% of them put that application in when they're 17, close to turning 18. And it's not because they arrive in Ireland when they're 17, it is because sometimes there are delays of up to 3 years for that application to be lodged. And again, it's because that responsibility is placed on the Child and Family Agency to do so. And you can see even the tribunal criticizing that in some of the decisions. But as you can see here as well, 50% of the decision of children receive a final decision after they're 20, which means that they spend at least 3 years in the process, and they actually have to go through an average length of maybe 8 to 9 interviews to get to that point. So when it comes to decisions concerning credibility in terms of nationality, as you can see there, it has diverged in terms as to whether some children from certain nationalities have had their credibility questioned more than the others. As you can see here, Afghan children all had their credibility questioned at first instance, but they all had that quashed on appeal, and they had the lengthier claims out of all the children that I looked at. And also one interesting thing, and it's not on the graph here, is that in Ireland, there are 23 different adjudicators that looked at these decisions. Out of these, 65% were female and 35% were male. The female decision makers, they actually set aside 68% of the decisions that they looked at, and they actually granted the child refugee status, while that the male decision makers only set aside 25% of these decisions. And while this is not on the scope of this particular paper, it's quite an interesting thing that I think should probably merit further investigation. So in terms of the influence of external actors, in Ireland, credibility in the way it is assessed and evidence itself tends to be more influenced by external actors such as social workers and medical experts, because they actually tend to assume a larger influence in the credibility context regarding issues that sometimes way beyond their remit. Social workers in particular play a huge influence sometimes on the outcome of cases at the appeal level. As you can see here in the claim concerning an Albanian minor at the appeal level, the social worker intervened during an interview and talked about the innocence of the child he was working with. And you can see in that written decision how much the social worker's testimony played a role in the outcome at the end. You can see that in several other decisions as well. And when it comes to legal representatives, you can see that a lot of children ended up in the appeal stage because they didn't have a legal representative, or because they simply fell out of the system in one way or another. So when it comes to the overuse of inconsistencies, as you can see here, I'm going to go very quickly through this one because I'm conscious of time. In this case, the child was punished for not knowing much about his father's job, and he was rejected at first instance, and eventually the case was set aside. But the problem that I had with this particular case, for instance, is that he was rejected or kind of not confining with predefined expectations placed on him in terms of presenting a self-narrated account that, was very much meshed with the guidelines as rigidly as they apply. So the credibility was not attached to what he was saying, it was attached to him as a child. And it was not the material factors that he was narrating that mattered in a way. It was more about how he presented himself as a child, or that didn't know what his father did, more or less. And then the next thing here then is that I tried to look at the way children's rights were used in the decision-making context here. And I think that these cases revealed that Ireland fell short of considering child-specific provisions when it comes to credibility. And this is reflected in a way in the lack of explicitly assessing credibility by virtue of considering the age and the maturity of the child, as well as by virtue of considering the evolving capacities of the child, as well as in the fact that the adjudicators, they tend to distance themselves from the process of engaging with child-specific considerations, I find it, because they have already constructed this kind of fixed, predefined notion of how a child's narrative ought to be like, based on the credibility guidelines that they use many times. I also note that it extends to the fact that, the adjudicators, as you can see through this graph, they really failed to engage with explicit child's rights provisions when it comes to protection considerations. And in that sense, they tend to fail to engage not just at obviously outlining if they have considered any children's rights considerations, but even outlining, for instance, whether they have considered the child's age, the child's maturity, the child's right to be heard, or whether they have factored any of that into the assessment itself. So when it comes to doing this, what I looked at is that the image of the child that emerges from most of the cases that I looked at is that one where capability is actually conflated with opportunism at times. and agency, meaning the child's ability to make their own decisions, it seems as being problematic. It seems being indicative of non-childlike behavior. So in a range of decisions, children's capacity to be resilient and to have their own decision-making capacity was questioned, especially if they demonstrated that. So I think here's some of the stereotypes that emerged out of the decisions that I looked at. Is that, first of all, the child that does not adopt the right lifestyle to sustain its claim, then the child who does not fit into the vulnerable mode, and finally, the kind of opportunistic and non-cooperative child. I'm going to go through a couple of these. The first one being the child who does not adopt the right lifestyle to sustain its claim. So in quite a few of the cases, especially in children who are applying on the basis of sexual orientation, I've noticed that in this case reflects that, for instance, this Macedonian child, they applied on the basis of fleeing because of their sexual orientation, but they found that he was inconsistent in the sense that he was not able to demonstrate that since coming to Ireland, his lifestyle had expressed or identified with any particular sexual orientation. And they questioned the fact that within his family life, that he was not demonstrating that sexual identity neither. But none of these bodies considered that in many ways, the stance that he had in his family may have actually propelled him not to identify himself in certain ways, or not adopting a certain lifestyle since arriving in Ireland. So his capacity here for independence and to have his own identity was suppressed in many ways. And the fact that he had not expressed or identified with any particular sexual orientation was used to reject credibility, what I believe is a form of identity prejudice, where the kind of stereotypes are used to sort of legitimize objective findings. They are not really that objective, considering how much room for discretion there is in the asylum process. So it seems that the child's here claim also failed due to the fact that he was not able to demonstrate that there was an inner struggle, you know, that their sexual orientation was part of their identity the way they should have, right? So I think the tribunal here really failed to consider the evolving capacities of the child and the fact that he left his country in one emotional state and he arrived in Ireland in another emotional state. And he was in the process for 3 years or so, meaning that many things changed throughout that time. And what they did is just they basically speculated about his lifestyle and gender identity without going beyond that. And then in this particular case, and I'll go very quickly through this one as well, is that in this appeal decision regarding an Albanian child, the adjudicator was really, really harsh in noting that the child did not exhibit any form of remorse for his choice between selling of drugs in Albania. So the child was involved in drug trafficking, and the child, on the basis, on the views of this adjudicator, did not fit the profile of a vulnerable teenager that would be coerced by fear of poverty to engage in that. And the reason for that is because he chose his role as a drug dealer. Therefore, he was not credible enough in terms of what he was asking for protection from. And the problem with that, once again, is that it involved negative stereotypes of young people when it comes to issues regarding drug dealing, but also the fact that it never referred to him as a child seeking asylum involved in drug dealing. All of the decision refers to him as a young man, even though he was still 17 by the time this written decision was put forward. So in terms of just concluding what I said, and I acknowledge, I think that my methodology has some limitations, that I only looked at written decisions that were in the archive itself during that period. And I chose 2016 to 2019 because that's when the new act came into operation, and I wanted to see how the act was being operationalized. But what I think some of these indicators reveal is that children's claims in the Irish context are deserving of further attention, including through exploring the experiences of these children going through that procedure. I think that a lot of the children were rejected at first instance on account of not confirming with predefined expectations that were placed on them. As I mentioned previously, credibility is attached to the child in this scenario and not to what they're narrating, to their account in many ways. And I think the cases show, as I mentioned beforehand, that the image that emerges from the decisions is one where the child's capabilities sometimes conflated with opportunity. And I think that this also demonstrates that there is a disengagement with children's rights when it comes to assessing credibility. So I think that's it. Thanks very much.
Thank you very much, Diego. Thanks for the very, very good timekeeping as well. This was indeed a very fascinating presentation. we're going to move straight to Sarah's presentation. So Sarah Lambrecht is a PhD student in migration law at Ghent University in Belgium. She uses a legal ethnographic approach, studying children's rights in appellate asylum proceedings in Belgium. She has a master in children's rights and childhood studies that she got in Berlin, an LLM she got in Maastricht, and a BA in Maastricht as well. And before her PhD, she worked as a researcher and policy advisor for the Children's Rights Knowledge Center for a number of years. And she was also involved in various research projects about children's rights and child abduction, led by the University of Antwerp. So, Sarah, yes, we can see already your PowerPoint. It's up. The floor is yours.
Thank you, Fabrice, and thank you all for having me here. I hope you can hear me well. I suppose so. Yes, so as Fabrice has said, I'm in my first year as a PhD researcher in the Migration Law Research Group of Ghent University with my supervisor, Ellen de Smet. My project is about children, young people and families in appellate asylum proceedings. And I will be conducting a legal ethnography of the Council for Alien Law Litigation, which is the Belgian appeal court in asylum matters. Persons seeking international protection and who received a negative decision at the first instance authority, called the CGRS in Belgium, they can appeal against this decision at the Council for Alien Law Litigation, which I will refer to as the CAL, CAAL. The CAL can either confirm or reform the first instance decision or annul it and send it back to the CGRS to start a new investigation. There's only one council in Belgium. It's located in Brussels. We have 54 judges in 9 chambers there who issue judgments in Dutch and in French. And my research deals with all the cases submitted by or on behalf of children, young people and families with minor children. And I abbreviate them on the slides as CYPF. All right. To set the scene for our discussion, I will first briefly introduce you to my research questions. Oh, that's a bit too fast. The key actors I will engage with, the different research disciplines and the corresponding research methods. Because it's a bit too early in my research now to present actual findings, I would like to discuss some of the methodological challenges that I experience in these early stages. And in particular, I will address selected topics in relation to case selection, managing field sites, and an ethical and human rights compliant use of participatory research methods. The research starts from the observation, which I suppose is more than obvious to many of you in this room, that the relationship between children's rights and appellate asylum procedures is fraught with a number of challenges and tensions. And from that state of the art, the question guiding my research is how children's rights are, could, and should be perceived, mobilized, and practiced by the key actors involved in adjudication of Belgian asylum cases in appeal before the Council. This question is divided into 4 sub-questions. To answer the first one, how do CAL judgments come into being? I will do a detailed analysis of a life cycle of a CAL judgment and discuss what role various actors play in the development of jurisprudence in asylum cases involving children, young people, and families. The second question is about the way in which different actors mobilize and practice children's rights in CAL cases. To what extent are these rights invoked by the parties and applied by the judges? In question 3, the perception of children's rights is central. And like Diego has just presented, I will also try to grasp the way in which various key actors involved in appellate asylum procedures perceive and conceptualize children's rights, and what impact this perception has on how children's rights are mobilized and applied, which also involves a question of child images. The fourth question concerns the careful formulation of recommendations to both the asylum framework and the children's rights framework. And when I speak of different actors, I refer to all stakeholders involved in appellate asylum procedures before the call. They can roughly be categorized in non-legal actors on the left and legal actors on the right. And I've divided them into core, semi-periphery, and periphery, not to indicate their importance in the procedure as such, but rather to represent my intended level of engagement with each of these different groups during my research. So at the core are children and young people seeking asylum alone or with their families, and on the other hand, call judges deciding on those cases. And other actors have an important role to play too. In the second circle, you find parents, guardians, representative of the first instance asylum authority, and more peripheral actors in the third circle can again be divided into non-legal professionals like interpreters, social workers, and legal actors like lawyers or attachés working at the call. And all of these actors have a different perspective on the legal reality of the procedure, while different interests are also at stake for each of them. The study builds on multidisciplinary methods at the intersection of law, anthropology, and childhood studies. To study the formal reasoning of the call and to see in which way children's rights accumulate in the actual decision of the court regarding the person's legal status, I'll be doing a critical analysis of relevant case law of the call. To look into the question on perception, mobilization, and practice of children's rights in the judgment's life cycle, I will engage with stakeholders to understand and analyze their unique perspectives. And this part of the research entails ethnographic fieldwork at the Council, as well as participatory qualitative research with key actors, including children, young people, and families themselves. The pillar of my PhD research that engages with stakeholders will make use of participatory methods. And with participation, I refer both to all the actors I introduced earlier, so professional stakeholders, but also the non-professional stakeholders, people who could be considered to be in a vulnerable situation. In my case, children, young people, and their families seeking international protection in Belgium. And where participation in research can have a lot of different meanings and levels of intensity, I see the choice of methods as placed along a continuum. The level of interaction and actual engagement will vary between an absolute minimum, where I'll be doing mere observations of people behaving in a certain way, to very extensive, because there's also a part in my research where I plan to do co-creative research. And participant observations, informal interactions, group discussions, interviews, they appear somewhere in between on this continuum. Each of the methods will have pros and cons, but combined, and if applied in a human rights compliant manner, I think that they could give me quite a holistic picture of what is at stake when discussing children's human rights in call procedures. Interaction with stakeholders as full co-researchers who would, for example, also co-design the research questions or co-author publications is not immediately an aim of the PhD project, but I will check pilot interviews and preliminary findings with stakeholders and make adaptations if necessary. So also from a methodological point of view, different stakeholders will be involved. At the moment, I've been 8 months in the research, and where I've spent most of my time on exploring the context I will be working in from a methodological point of view. And for each of the 3 methodological bubbles, I've identified one issue that I would like to discuss with you. In the context of the case law analysis, I will look at the topic of case selection. For ethnographic fieldwork, I will discuss the issue of accessing the fields. And in relation to participatory qualitative research, I will look at the development of a human rights-based approach to research. And I do this not only because I'm very much looking forward to your experiences in tackling some of these challenges in your own work, but also because they might be insightful for future research on fair asylum proceedings and more broadly on research that affects minors below 18 years old. So starting with the first challenge on case selection. In the context of my case law analysis, the outcome of what I will be able to say about the court's formal reasoning in its case law depends on the selection of a suitable sample of cases. The call issues about 800 to 1,000 judgments a year that are relevant to my research. So that is a lot, and I will thus have to make a careful selection of cases based on clear criteria. And at this point, I experience a tension between the advantages and disadvantages of, on the one hand, a broad and random sample that includes all types of call cases in which minors are involved, and on the other hand, studying a limited number of cases in depth. In a broad analysis of, for example, 250 cases, there could be multiple variables that could be interesting to investigate in relation to the role children's rights play in the judgment. For example, distinguishing between the minor's legal position as an unaccompanied or accompanied minor, distinguishing between different age categories, identifying child-specific grounds for persecution, such as FGM or child marriage. Also distinctions between different countries of origin, or even differences in approaches between the various chambers within the call. And also the issue of time could be a relevant marker, which timing for the sample to choose. On the other hand, an in-depth analysis could look beyond the actual text of the judgment, also including the decision's life cycle all the way from the applicant's arrival to the stage of appeal. And when speaking to lawyers or guardians or social workers and first instance migration authorities, it becomes clear that each of these intermediaries on their own and in relation to each other have a crucial influence on the way in which children's rights reach the appeal decision of the judge. And each of them also produce documents in which the formal reasoning of the authors and institutions behind them is reflected. Such an analysis would have a more limited sample, for example, 10 cases only, but could possibly reveal a treasure of information about where, why, and how children's rights appear at certain stages of the procedure and not at others. And this dilemma between breadth and depth is quite thought-provoking for me at this point. The way I chose now to tackle this issue is to start from a broad sample covering as many different variables as possible and move from there to an in-depth analysis of a limited number of cases that would be illustrative. These in-depth cases could include not only the appeal judgment, but could, if access allows, also include the life cycle of the entire asylum procedure leading to an appeal stage. The question of balancing depth and breadth also triggers another question, not in the case law analysis this time, but in the approach of my ethnographic site. When studying an appellate asylum procedure in Belgium, the call itself seems the most obvious place to observe. Questions like, how do judges navigate procedures involving children, young people, and families? Is their behavior or interaction in any way different from cases involving only adults? How do they speak about children in their absence or in their presence? Are children accommodated, taken care of? How do families experience a visit at the court? These type of questions. But for interactions with respondents who are present at the call and that take place on call premises, we have negotiated a memorandum of understanding between the first president and a liaison judge and myself. And this has proven a very productive way of engaging in this type of relationship of accessing the fields. We made arrangements about my presence and decided upon reciprocal ways in which we can exchange knowledge and expertise. And this transparency and dialogue seems crucial. But most children, young people, parents, and families will be involved in the research by virtue of their experience with the legal procedure, and thus will become part of that experience in a way. The idea is that I will spend most of my time at the council, up to 1 year, to do the ethnographic fieldwork. But a thorough study of an appellate procedure may be impossible without the inclusion of other sites, such as the lawyer's office, minors' consultation with the guardians, navigation through the procedure at first instance, daily lives in communities or schools. And where I've now thoroughly prepared my fieldwork, it's maybe questionable, and this was also raised yesterday by you, Fabrice, in your presentation about the French experience, whether the court itself is actually the most relevant place to observe the experienced children and other appellants have in navigating these procedures. If all other sites in which they experience their life as asylum seekers in Belgium, if these sites would all be left out of the analysis. And at the same time, and this leads me to a challenge of a more ethical nature, I'm aware that as an institution representing authority and decision-making with a great impact on people's lives, the call is not a neutral setting. And this should the research take place only on call premises, it's assumed that it may be more difficult for children, young people and families to truly experience their participation in the project as a voluntary choice, to opt out of the research if they so wish, or even to just access them in the first place, as was also raised in earlier presentations on the ASYFAIR team. I foresee that most of the interactions taking place at the call will be of an informal nature, like observations and informal interactions, and that I will need to make further arrangements to meet participants in a safer setting of their choice for group discussions, interviews, co-creative workshop sessions. And these could be, for example, in the participant's own home, in a community setting, at school, or in reception center, or any other place of their choice. And taken together, this would add up a lot of different sides, and the balance between breadth and depth may again reach a critical tipping point. The need for diversifying does not mean that all of these settings should become ethnographic field sites, but I'm curious now if the aim of the ethnography is to understand the role of children's rights in appellate asylum procedures. Probably observations at the call may be too limiting. Tackling this issue is a bit more challenging since the fieldwork has not yet started. I assume that starting local at the call would be a valid approach to take. And from there, I could then determine what sites are crucial and require further investigation, possibly broaden up the sites that I need. To decide which sites that would be, speaking to children, young people and their families would be an essential stepping stone. Where the voices of children, young people and their families come in, the third challenge I want to address is related to the use of participatory research methods. In my application to the Faculty Ethics Committee, I claim that my research will be human rights based, in accordance with the work of other scholars who have undertaken similar attempts. I stated I want to build on and learn from children and young people's views, create opportunities for positive interaction about their asylum procedure, actively involve them in a way that maximizes benefits and minimizes risk, and ensure that all children, young people and families have equal access to participation, irrespective of inequalities such as disability, language, or gender. I've been thinking about this a lot, and I've come to realize that I wouldn't be able to do research about children's rights without actually trying to contribute to the realization of these rights in the little moments that will be given to me during my interactions. And when I try to grasp what this means for me and how I can translate this into action, I came to see it as my role to be open for the challenges research participants identify throughout an asylum procedure and make the search for change or suitable solutions an inherent part of my research. Adding the participatory dimension to the case law analysis and ethnographic fieldwork seemed one way of meeting this concern. And these methods would also allow me to map the lived experience of children, young people and families of an appellate asylum procedure before the call. At the same time, when I combine their insights with the findings from the case law analysis and the ethnographic fieldwork, I will ask them to join me in developing adequate responses to different challenges. This will be done in a co-creative manner involving different stakeholders. And it's my hope that on a meta level as well, the project can contribute to the development of a human rights-based and multidisciplinary methodology in this type of scholarship. Gradually, I might be coming to a possibly fifth sub-question in my list of research questions, as in what does it mean in practice to research appellate asylum procedures involving children, young people and families in a human rights compliant way? I'm curious to discover answers to this, and I'm very much looking forward to hear your questions and comments. I've prepared some questions myself, but of course, I'm happy to hear from you as well. If you would like to contact me at a later stage, you can find my contact details here. Thank you. I hope I didn't overrun the time too much.
Thank you, Sarah. You actually didn't, so that's fantastic. Thank you very much to all of you. Please check the speaker's email if you want to contact them. They're all on the leaflet you received. And see you later.